Hi, it's your partner again in Criminology Reviews. How have you been? Were you still following our page? If not, please support and subscribe, then click the notification bell for more criminology-related contents. Thank you. And now, we will proceed on our discussion with Article 11 of our revised Penal Code. Some of you remember these articles as JEMA, but we will discuss it one by one. And the first topic will be Article 11, which is justifying circumstances. So what is justifying circumstances? Are those circumstances which, if present in the commission of the crime, the offender is said to have acted within the bounds of the law. The offender is said not to have transgressed the law. Hence, there is no crime committed, there is no criminal liability, and there is also no civil liability. Justifying circumstances, or the presence of justifying such, is both an admission and avoidance. If the accused invoked any of the justifying circumstances under Article 11, he is in effect admitting the commission of the crime, but at the same time avoiding the criminal liability thereof. Therefore, the burden of evidence now is on him to prove the justifying circumstance that he is invoking. The moment an accused invoked any of the justifying circumstances under Article 11, trial will be inverted. It is the defense that must present first the evidence to prove the elements of the justifying circumstance that the accused is invoking. Otherwise, it would be a conviction. A was charged with homicide. During arraignment, he pleaded not guilty. The judge asked the counsel, "Counsel, what is your defense?" The counsel said, "Self-defense, Your Honor." The moment the judge learned that the defense of the said accused would be self-defense, trial will be inverted. In regular trial, it is the prosecution that must first present the evidence to prove the guilt of the accused beyond reasonable doubt, but if the justifying circumstance is invoked, the judge will require the defense to first present its evidence. The defense has the burden of proving the justifying circumstance that he is invoking. If the defense failed to prove the justifying circumstance that he is invoking, definitely there is conviction, because in effect, the accused already admitted the commission of the crime. Now, it is stated under Article 11, the following do not incur criminal liability. 1. Anyone who acts in defense of his personal rights, provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. This is otherwise known as self-defense. Self-defense does not only include defense of one's life and limb. Self-defense also includes defense of one's honor and chastity. It also includes defense of one's property, if coupled by an attack on the person entrusted with the said property. Now, let us talk about its elements. Elements of self-defense. Elements of self-defense are 1. Unlawful aggression. 2. Reasonable necessity of the means employed to prevent or repel it. 3. Lack of sufficient provocation on the part of the person defending himself. The first element of self-defense is unlawful aggression. The unlawful aggression must come from the victim. The Supreme Court said that unlawful aggression is the primordial element in self-defense because without unlawful aggression, there is nothing to repel. Hence, self-defense will not lie. So before we proceed, let us first understand what is unlawful aggression. What is unlawful aggression? Unlawful aggression refers to any act done or material attack that places the life and limb of the person defending himself in actual or imminent danger. Elements of unlawful aggression. PA1. There must be a physical or material attack or assault. 2. The attack or assault must be actual or at least imminent, and 3. The attack or assault must be unlawful. The test for the presence of unlawful aggression under the circumstances is whether the aggression from the victim put in real peril the life or personal safety of the person defending himself. The peril must not be an imagined or imaginary threat. 2 kinds of unlawful aggression. 1. Actual or material unlawful aggression. Actual or material unlawful aggression means an attack with physical force or with a weapon, an offensive act that positively determines the intent of the aggressor to cause the injury. 2. Imminent unlawful aggression. Imminent unlawful aggression means an attack that is impending or at the point of happening. It must not consist in a mere threatening attitude, nor must it be merely imaginary, but must be offensive and positively strong. Like aiming a revolver at another with intent to shoot or opening a knife and making a motion as if to attack. Imminent unlawful aggression must not be a mere threatening attitude of the victim, such as pressing his right hand to his hip where a revolver was holstered, accompanied by an angry countenance, or like aiming to throw a pot. Yabid. Second element. The second element of self-defense is reasonable necessity of the means employed to prevent or repel the unlawful aggression. Reasonable necessity means that they used, or the means employed or the weapons by the person defending himself must be rationally necessary in order to repel or to prevent the unlawful aggression being given by the victim. When you say reasonably necessary, it doesn't mean perfect equality of weapon. It doesn't mean that if the unlawful aggressor is using a knife, the person defending himself must also use a knife. It suffices that the means used by the offender, by the accused or the person defending himself is rationally necessary in order to prevent the unlawful aggression. Third element. The third element of self-defense is lack of sufficient provocation on the part of the person defending himself. Provocation refers to any improper act or conduct which excites or incites a person to do a wrongful act. Provocation is said to be sufficient when it is adequate to stir a person to commit a wrongful act and when it is proportionate to the gravity of the act. So that is all about self-defense. What it implies is the rule behind self-defense is stand ground when in the right. What does it mean? Stand ground when in the right means that when the accused is where he should be, the rule does not require him to retreat when he saw his assailant fast approaching him with a weapon. For if he retreats, he runs the risk of being stabbed on the ground. Stand ground when in the right. Now, let us proceed to our second justifying circumstance. 2. Anyone who acts in defense of the person or rights of his 2.1 spouse, 2.2 ascendants, 2.3 descendants, or 2.4 legitimate, natural or adopted brothers or sisters, or of 2.5 his relatives by 2.5.1 affinity in the same degrees, and 2.5.2 those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite I. In case the provocation was given by the person attacked, 2. That the one making defense had no part therein. Elements of defense of relatives URP1. Unlawful aggression. 2. Reasonable necessity of the means employed to prevent or repel it. 3. In case the provocation was given by the person attacked, that the one making defense had no part therein. Note: the law gives a leeway on the third requisite, even if the relative being defended gave the provocation. If the relative making the defense had no part therein, he can successfully invoke the defense of relative. So, these are the elements of the second justifying circumstance, which is more popularly known as defense of relative. In defense of relative, we have to take note of the relatives which may be defended, even if the person being defended is a relative, but he is not among those mentioned in Article 11, second paragraph. Then, it cannot be considered as defense of relative, but rather it is defense of a stranger. And now, for our third paragraph will be defense of stranger. 3. Anyone who acts in defense of the person or rights of a stranger, provided that 3. 1. The first and second requisites mentioned in the first circumstance of this article are present, and 3. 2. That the person defending be not induced by 3.2.1 revenge, 3.2.2 resentment, or 3.2.3 other evil motive. Elements of defense of strangers UR1. Unlawful aggression. 2. Reasonable necessity of the means employed to prevent or repel it. And 3. Person defending be not induced by revenge, resentment, or other evil motive. Person considered as stranger any person not included in the enumeration of relatives mentioned in Part 2 of Art 11. So, this is otherwise known as defense of a stranger. Again, we have already discussed the first element of unlawful aggression as well as the second element, reasonable necessity of the means employed to prevent or repel the unlawful aggression. How about the third element? That the person defending be not induced by revenge, resentment, or other evil motive. What does it mean? It means that in order for defense of a stranger to lie in favor of the accused, it is necessary that the said accused, in defending the stranger, must be ignited only by a disinterested and lawful objective of helping a total stranger. He must be ignited solely by disinterested and lawful objective of helping a total stranger. He must not be ignited by ill motive like revenge, resentment, and the hatred, etc. Now our fourth justifying circumstance is state of necessity. 4. Any person who, 1. In order to avoid an evil or injury. 2. Does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. Third, that there be no other practical and less harmful means of preventing it. Elements of state of necessity, e.g. 1. That the evil sought to be avoided actually exists. 2. That the injury feared be greater than that done to avoid it. 3. That there be no other practical and less harmful means of preventing it. Note: state of necessity can only be invoked by a person who is not the author of the state of necessity. So, this is the fourth justifying circumstance. This 4th justifying circumstance is otherwise or more popularly known as state of necessity. The offender, in order to prevent any person, or in order to prevent an evil or injury, he does an act which causes damage to another person. It is a state of necessity, and the offender is justified in causing the damage if the 3 requisites are present. That the evil sought to be avoided actually exists. That the injury feared be greater than that done to avoid it. That there be no practical and less harmful means of preventing it. In justifying circumstances, if it is present in the commission of a crime, there is no criminal liability and civil liability. An exception to that is paragraph 4, state of necessity. In case of state of necessity, there is no criminal liability, but there is civil liability. Civil liability in state of necessity shall be borne by all persons who have been benefited by the said state of necessity. The 5th justifying circumstance will be fulfillment of duty. 5. Any person who acts in the 1. Fulfillment of a duty or 5.2. In the lawful exercise of a 5.2.1. Right or 5.2.2. Office. Elements PC 1. Accused acted in the performance of a duty or in the lawful exercise of a right or office. And 2. Injury caused or offence committed be the necessary consequence of the due performance of duty or the lawful exercise of such right or office. Under this 5th justifying circumstance, it is necessary that the resulting injury must be the unavoidable or the necessary consequence of the lawful performance of duty of the said accused. And now for our last justifying circumstance will be obedience to higher order. 6. Any person who acts in obedience to an 6.1 order issued by a superior 6.2 for some lawful purpose. Elements OL1. That an order has been issued by a superior. 2. The said order must be for some lawful purpose. 3. The means used by the subordinate to carry out the order must also be lawful. So, in this last justifying circumstance, it is not only necessary that the order issued by the superior must be lawful, it is equally necessary that the means used by the subordinate to carry out the order must also be lawful. Otherwise, there cannot be a valid justifying circumstance. So those are the justifying circumstances present in the revised penal code. Now, let us talk about battered woman syndrome. A justifying circumstance which is not present in Article 11 of the revised penal code is found under RE 9262. That is the so-called battered woman syndrome BWS. BWS refers to a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationships as a result of cumulative abuse. Under Section 26 of RE 9262, it is provided that victim survivors who are found by the courts to be suffering from battered woman syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements for justifying circumstances of self-defense. That is all about Article 11 of the revised penal code, which is justifying circumstances. I hope you have watched and make your own notes. Before you continue your review, please support our channel by subscribing and clicking the notification bell. Stay tuned for our next discussion on Article 12, exempting circumstances. This is your Criminology Review partner. Until next time.